Awesome. All right. My name is Rebecca Tinder. I'm the West Virginia We the People Coordinator, and I have now brought our judges with me, and they will introduce themselves. The students will introduce themselves and their teacher, and then their teacher will also hide his video. And then we shall begin.
Don't worry, Joe.
You won't believe what I just said. Congratulations on winning, and we are here to listen to you today. My name is Joe Stewart. I teach in the political science department at Clemson University in South Carolina. I've been involved in the program for a long time and very much enjoy these opportunities to meet with you and to learn what you've studied and hear what you have to say.
Well, what was funny is I was telling you were on mute and I was on mute. So there's not a day that goes by without saying somebody's on mute. My name is Lynn Simons, and I'm the Chief Judge for the 2nd Judicial District Court in the state of Nevada. And I just am an ardent fan of We the People and contributing my time and energy to it and listening to all the fascinating testimony and questions and answers. So I'm really looking forward to our conversation today, particularly because I did Unit 6 all weekend. So this is fresh and new to me. And I'm just going to ask you to pause for a minute and take a deep breath in preparation.
All right, now I'm going to ask you to exhale. So we'll go from there. I'm Hank Chambers. I'm a law professor at the University of Richmond out here in Virginia. It's good to see you all. Been at this for about 25 years, whether it's judging or being a scholar in the program. I look forward to the conversation this afternoon because Wisconsin always brings it.
Please introduce yourselves and your teacher.
Hello, we are Unit 4, juniors representing the state champions from Wisconsin, Wauwatosa West High School. We are here on behalf of our teaching assistants, mentors, and teacher, Mr. Chad Mateski. I'm Matthew Byrne.
I'm Sarah Cape. I'm Hannah Vienendahl.
Okay, thank you. Well, we are dealing with question 2 today in Unit 4. So I will read that. The president ought to communicate such papers as the public good would permit and ought to refuse those the disclosure of which would injure the public. Do you agree or disagree that the executive can withhold or disclose information at her or his discretion? To what extent, if any, has the claim of executive privilege expanded presidential power since its inception? Are the constitutional powers that enable the other 2 branches to counter executive privilege claims sufficient? Why or why not? You may begin.
Senator Samuel J. Ervin Jr. said, "The president is entitled to keep secret those conversations which a president may have with his aides for the purpose of advising him in his constitutional duties. The use of executive privilege is vital to the efficiency and effectiveness of the executive branch."
Though not explicitly stated in the Constitution, executive privilege is rooted in Article 2, Section 2, under the Separations of Powers Doctrine. Executive privilege can be traced back to 1792, when George Washington refused to turn over documents regarding a failed military operation. Historically, executive privilege has been applied to issues regarding intragovernmental communications, foreign affairs, military relations, and pending investigations. We agree that the president should withhold information at their discretion if used to promote effective governance, protect confidentiality, and enhance national security. The government cannot function without some level of confidentiality. Dwight D. Eisenhower refused to allow his advisors to testify at a Senate hearing in May 1954. Eisenhower believed that what is said in the White House should stay in the White House, promoting effectiveness throughout the executive branch. The president and those who assist them must be free to explore alternatives in the process of shaping policies and making decisions, and to do so in a way that can be expressed candidly. That said, it is imperative that the president acts virtuously in order to protect the common good, as we recognize executive privilege can be easily abused. There are several examples in recent history when executive privilege has been used for personal or political gain. Former President Barack Obama abused the power following Operation Fast and Furious in order to protect himself and his cabinet. Additionally, after the January 6th insurrection, President Trump refused to give papers to the chair of the House committee that could have possibly linked him to the event.
Over time, powers of the executive in general have expanded, not because of the privilege itself, but rather the ambition of the president. This can be seen when Grover Cleveland invoked executive privilege during a time of peace for the first time, setting precedent. During wartime, however, presidential secrecy expands significantly as the president must withhold more information in order to protect national security. Today, executive privilege is expanding to a whole new level. In response to the January 6th investigations, former President Trump has attempted to claim executive privilege for himself and others despite no longer being in office. He wants to carry that protection with him out of office and extend it to cover people like Steve Bannon, who have no official government position. Moreover, the advancement of technology has allowed international access to public government information, increasing the need for a certain degree of secrecy within the executive branch.
Some think the expansion of executive power is harmful to our system of checks and balances. If secrecy of the executive branch overpowers Congress's ability to enact legislation and exercise oversight, it undermines Congress's core functions. Several checks on executive privilege exist, such as Congress's investigative authority to issue a subpoena or use inquiry to conduct oversight. Congress's ability to impeach under Article 1, Section 2 also discourages an executive from abusing power. In addition, the Supreme Court can exercise judicial review, as seen in U.S. v. Nixon. Finally, the voters can ultimately vote out candidates if they feel there was a misuse of executive privilege or presidential power. That being said, the checks that do exist on the executive branch are not always sufficient in limiting executive privilege. The amount of time investigations take can impede their effectiveness because people can refuse to testify or refuse subpoenas without many limitations or punishments. The judicial checks are also limited by various factors, including the political question doctrine, case or controversy requirements, and lack of precedent. As George Washington said, "I have no disposition to withhold any information which the duty of my station will permit, or the public good shall require to be disclosed." Executive privilege is a necessary and important power when used appropriately. The president must use integrity when invoking this privilege to protect the interests of the country. This concludes our statement. We are now ready for follow-up.
Thank you. Appreciate the statement. You've argued that the development of technology means that it's important to maintain security and secrecy. Is that even possible anymore? Could that logic undermine the need for executive privilege?
It is not possible anymore, but it depends on how the president uses technology. As seen by President Trump, who used Twitter to express his daily thoughts and feelings, he did not allow much secrecy to happen within the executive branch because he shared so much on Twitter, and Twitter eventually did block him.
Additionally, this newfound information that has been shared on information that is seen worldwide is often not information that would have been protected under executive privilege itself, except this does lead other leaders to have more insight into the lives and doings of our government, and which can be seen as not good for our process of creating laws and working effectively.
An example of what my colleague is referring to is when former President Donald Trump exposed his phone calls with the president of Ukraine. Now, although that was a beneficial move for his party, ultimately it undermined the value that we hold in executive privilege because it let other foreign leaders know that the conversations that they were going to be having with our president were not going to be candid, which is an issue, and it doesn't withhold our value of executive privilege itself.
Private corporations such as Twitter have limited presidential, such as Donald Trump's, access to tweet things, especially following the January 6th insurrection. Because of this, we can see that the private sector has taken into account that there can be limits on presidential usings of public domains, such as Twitter.
So, there's concept that power corrupts and absolute power absolutely corrupts. And you've talked about that your position is that this privilege is vital to efficiency and effectiveness. But you also noted that personal presidential ambition has expanded the privilege. Do you think that a clear opinion from the United States Supreme Court regarding what should be privileged and what is not should occur?
I think that that would be very beneficial to occur because there has been no direct result from a court case directly limiting or directly defining what is executive privilege. But this is honestly not very realistic. Because of case and contrary restrictions, it is very hard for this to actually come about from the Supreme Court.
To your question, absolutely. The Supreme Court needs to define the limits of executive privilege, specifically who it extends to. We can see that with in the Obama administration, former President Obama issued many different czars, such as the Ebola czar towards the end of his presidency. And it becomes, because the power of executive privilege is so ambiguous, we don't really know who that extends to, and that can be dangerous. So a Supreme Court ruling defining that would be extremely beneficial.
There should absolutely not be a limit placed on executive privilege because it is rooted within the Constitution in Article 2, Section 2. And it is very important that the president is able to have secrets in order for the branch to run effectively.
Do you think that if there were, excuse me, just one follow-up, if they did issue such, do you think it would be clouded by politicism based on the appointees?
It should not be clouded by politicism, as the judicial, the judges, the judges in the Supreme Court are supposed to remain apolitical according to the founders, so there shouldn't be any politics being brought into their decisions.
I believe my colleague was saying justices, and I do think that it would be clouded with politicism, although it is nice to think that the Supreme Court has remained apolitical. This has obviously not been the case that has happened. And even though this would be a perfect world ideal, it just does not feasibly would happen in the court that we have today.
Furthermore, there are 3 different ways that justices can look at the Constitution, whether it be living constitutionalism, originalism, or textualism, which has different parts in the political parties, which leads to there being politics within the branch.
So should the president be allowed to claim executive privilege with respect to advisors who do not work in the government? You all mentioned Steve Bannon before. What's the problem with allowing executive privilege with respect to his advice?
The problem is that he's not a part of the executive branch, but it's also the fact that it's an inherent power. There's really no, again, limitations to it. So personally, this could be beneficial to have it so that other people can also use executive privilege as long as the conversation was with the president themselves, between them, because that candor between conversations, whether it be a member of the US government or a president speaking with a foreign leader, it's extremely important that those conversations in the name of national security are kept secret.
Even though secrecy is helpful to the executive branch in its runnings, we still need to have a check. The people need to be a check on the president themselves. The president is awarded a huge amount of power. The budget last year of the government was $6.8 trillion, and the president is head of the largest military in the world. We need there to be not full secrecy, only secrecy that would benefit the public, because we need to keep an eye on this president to fulfill what the people truly want.
I disagree. There should be important amounts of secrecy within the executive branch, as seen by Obama's use of czars, who are governmental positions but are not appointed by Congress. He used an Ebola czar to talk about many different things going on with that virus, and it is important that conversations are kept quiet as a matter of national security.
Is there a difference between withholding information from the public and withholding information from Congress?
There is not a difference. When the president enacts executive privilege, they're doing so because they believe that it's protecting national security or making sure that what they're doing is effective in their branch. Whether they keep information from the public or Congress, they're doing it because ultimately they feel it was best for the common good. And this was seen throughout history, whether it be Thomas Jefferson in 1807 or during U.S. v. Reynolds, when they withheld information from families during a army situation.
Congress should be able to be granted access to some information that the public doesn't. Through Article 1, Section 1, Congress has power to to investigate and to oversee other branches of government, including the executive branch. And so many of these investigations or oversight being used should be able to have further inquiry into documents and information that the public doesn't to fulfill their legislative jobs.
There should not be a difference between the information shared with Congress and the information shared with the people, as the people are as stated in Federalist 49, the people are the only legitimate authority of power. And this is seen through the Pentagon Papers when they were released. It was important that the people were able to be knowledgeable of what was going on with the US involvement in the Vietnam War.
Additionally, during the Manhattan Project, there was secrecy held between the executive branch and the legislative branch. There was only a small amount of legislative employees that knew this information, and it was extremely necessary that the public didn't know this information to help the war and help the efforts that the Manhattan Project promised for society.
My understanding is that they also didn't tell Harry Truman about that. Is it in the public's interest that a vice president not know what's going on in the executive branch?
That call is up to the president, him or herself. If they feel that information should be withheld from the vice president, then they can make that decision themselves. There's a certain level of virtue within the position as president or just within the executive branch that has been seen throughout our entire history, as the Constitutional Convention was held behind closed doors. And that virtue is carried through with the president, and they have to make that decision to determine what information is best to be withheld from what people.
As stated in Federalist 10 and Brutus 11, men in office are tenacious of power. So it is important that they act with virtue, and it is important that the people trust the executive, as they are the ones putting them within the power. So it is important that the executive acts with virtue and decides to make the best call for the people.
Would it be helpful to draw a distinction between executive privilege and presidential privilege? Would you do that, and what use might that serve?
The unitary executive theory says that there is a hierarchy within the executive branch. The president is in charge of the executive branch. So because of that, there is more responsibility and there's more power within that. But that doesn't take away the fact that executive privilege has historically been and is a power of the entirety of the branch.
Additionally, executive privilege is a separate power than many of the other presidential powers, which there should be this separation because not all presidential doings need to be secret so that they can still be held accountable by the public.
Thank you. Wow, that was a wonderful discussion we had. And it's clear you are well prepared to wrestle with this issue. I wish we had even more time to discuss this with you. I would caution you to be careful hearkening back to the time of an apolitical Supreme Court. I believe the first Supreme Court where we had politics making a difference was some guy named George Washington. But all in all, that I really enjoyed the conversation. I thought you touched on a number of issues and wish we had more time to deal with that. So very good job representing Wisconsin.
Thank you.
I really enjoyed this. I thought it was very well done, and you took a position. It was really clear. But in our questioning and even in your testimony, you gave up some weaknesses to that position. You acknowledged challenges to your position, which really, and I think the way you supported it showed that it not only is it an ideal, but that you firmly believe in the position and you're going to defend it. In addition, I liked your richness of examples and how you wove in, even possibly from studying for the other question, but you wove in information that was interesting, and the whole concept and how you pointed out the czars, I think was very effective. And you weren't afraid to say, no, Banyan can't be protected under this. I mean, you took and then what I like is also the concept of virtue. It was refreshing that you aren't cynical, and I appreciated it. Thank you.
Thank you.
Definitely good stuff from Wisconsin. Lots of good background information. There are a couple things that just moving forward, you may want to consider, and that is context in terms of the people who are involved. So Sam Urban, for example, is an interesting one to use considering his place in Watergate, to talk about the concept of the efficiency of needing secrecy in the executive branch. Eisenhower, of course, is another one who's kind of interesting to talk about, considering that he was not just talking about secrecy inside of his White House, but also secrecy with people who were outside advisors who were not inside the government. So real interesting notion of thinking about Ike being okay, but Bannon not being an appropriate person to get coverage for executive privilege, which is not a suggestion to say that Bannon should be. It's just to say that it's an interesting way of looking at those issues. Congress, in terms of their checks, you laid out a number of checks and suggested that maybe that was not sufficient. I thought it was sort of an interesting issue. You mentioned political question doctrine, which I think is a real important one, but particularly important because maybe the judiciary ought to stay out of the matter. But you guys had a legit role for the judiciary as well. So in the grand scheme of things, it was a nice wide-ranging conversation touching on lots of things and lots of questions, and not 100% clear answers, not from you all, but not 100% clear answers that the Constitution gives. So I think y'all did a wonderful job, and it's always good to see y'all from Wisconsin. So go Wauwatosa West. Didn't make the mistake of calling y'all Wauwatosa East. That would not be cool.
And Chad, congratulations on your fatherhood too. So.